speakers, I'll let them introduce themselves. So Carlyn, do you want to go first?
Sure. I'm Carlyn Epstein. I am privacy counsel for Clorox. I'm primarily responsible for negotiating privacy and security provisions in commercial contracts. Before that, I was with Axiom for a number of years, representing a wide variety of clients and a wide variety of industries. And the good news is, unless you're in a highly regulated space, privacy issues in contracts tend to be the same no matter what industry you're in. And so hopefully today is going to be useful for you.
Wonderful. And Raella.
Hi, my name is Raella Dyke. I work for HP Inc. in Austin, Texas, where I met Laura. And I worked with Carlyn at HP for a brief period of time. I manage our sales support process for the cybersecurity org. Prior to that, I worked for Dell, also handling privacy and security contracts as well there. So do live and breathe the tech space, love it. I'm very excited to be here.
Awesome. Well, let's get started. So I'm going to be leading on the PowerPoint changes. So you may hear Carlyn and Raella kind of give me a hint to change the slide. So why don't we get going? I'll go ahead and switch to the first slide.
Sounds great. So cybersecurity, very exciting, kind of a hot button lately. I want to cover a couple scoping things, and hopefully Carlyn and Laura will jump in if they have any thoughts or any questions. So cybersecurity is the industry that's sprung up around controlling access to technological things. You want to make sure everyone who can access your systems, your hardware, your software, your data, your network is authorized to do so. That's the purpose. I mentioned data. If there's data involved, you're also raising privacy concerns. So that's where Carlyn is going to be here to support that portion of the discussion. With cybersecurity, it's helpful, I think, to think of it as a toolbox. So cybersecurity is your wrench, it's your screwdriver, it's your hammer. And then you look to often other spaces for the blueprint. What are we going to do with our cybersecurity? So with privacy, what we're going to do is help you keep your data private. If you are the NSA, on the other hand, maybe what you want us to do with that toolbox is make sure that we have less privacy or that we have more insight into what is happening. So cybersecurity is the toolbox, and the other areas, BCP, to some extent anti-corruption, they give you a sense of what you want to do with that toolbox.
And PCP, what does PCP mean?
I'm sorry, BCP, business continuity, disaster recovery. We see some overlap there.
Oh, okay.
It's physical security, just other spaces that utilize the cybersecurity toolbox to achieve their goals as well. Good question.
Got
Yes.
it. Thanks.
Catch me if I use acronyms too much.
No worries.
It's a corporate liability when you when you're in that world. Another thing to consider is, when do we need a cybersecurity contract? If you are buying plastic forks for your cafeteria, you obviously do not probably need cybersecurity provisions in your contract. The easy way to think of that is three things. Do you have connectivity? Is there connectivity with a system, with a network? Are they hosting a web portal? Any sort of connectivity. The second thing is data. Are they processing data? You may not be connected, but somehow they have your data. They are handling it in some way. And again, that raises the privacy aspect as well. The other is development. If they are developing software for you, hardware for you, there may not directly be connectivity with you. They may not have your personal data, but they're developing it, and you want to make sure they develop it in compliance with the secure development lifecycle. So development, connectivity, data. Those three things mean that you need to have cybersecurity terms. This is the ground state to look for whenever you are encountering any sort of risk mitigation. I think, as most of us know, in cybersecurity, you really can't contract away all of the risk. In many cases, it will be there. And one of the ways of mitigating that is to have this first, I think of them as pillars. I guess here we have circles. But this first circle, which is due diligence, if you're going to contract with someone and you have security risk there, you should go in and conduct your due diligence to make sure that you are comfortable with their security practices. And I know, Carlyn, on the privacy side, I think there's an emphasis on doing this as well. Would you say that's standard for privacy?
Sorry, I couldn't hit the unmute button.
No, no worries. I have 2 mute buttons, so I'm not fast to toggle. So that's fairly common. Once you've established that you're comfortable with their practices, you then move to contracting, which is our focus today. Contracting allows you to ensure they maintain that same level of security throughout the engagement. And you also want to give yourself the right to go in and look at what they're doing to make sure that's happening, because you also want to carry on ongoing oversight. You can't just sign the contract, throw it over the wall and be done. So 3 stages here, and they play into how we negotiate the terms of the contract as we move forward. And we can jump to the next slide, I guess. Does it let me manage?
Oh, I'm sorry. Oh,
I'm sorry.
okay.
I'm looking for the.
Did you want to go to the
Okay,
next
that
slide?
works.
Yeah.
Yes, perfect. So in light of the 3 risk mitigation stages that we just looked at, this is one of the most important provisions for you in a security contract, which is the right to audit. And I'll talk to it both from the vendor side and the customer side. A lot of security contracts are B2B, they're business to business. So you're not usually going to be contracting over much with an individual or a consumer. In B2B, you're going to run into these provisions that give the customer the right to come in and audit the supplier to ensure they're compliant with the terms of the contract. It may include any applicable regulations. It may link to the due diligence results. If you have a third party go in and audit your vendors and they produce a report for you, you may audit against that. So you have a couple of options here. As I look at this language, a couple things jump out that I want to talk to. First, you really do want to scope these provisions to the services that you're providing the customer. I see a lot of customer templates come through and they're scoped to your entire company. And that creates a couple of issues. One, the resource demand for that kind of thing is a lot bigger. It also creates confidentiality risk. They may be exposed in some ways to data that involves your other customers, pricing, proprietary, and it's not relevant to what you do for them. So the first change I would make here would be to add a relevance requirement. So it does say compliance with the terms of this agreement. You can add something here, that the audit will be scoped to the services provided, or the scope of the audit will be mutually agreed prior to the beginning of the audit, something along those lines. You'll want to finesse it a bit. The second thing I would address here, and this does again go to scope, it says we will accommodate all customer requests. Again, you want to make that customer request for materials relevant to the services provided. I would also limit this to a documentary audit. Some customers will want to come in and scan your system, scan your network. Again, that creates some confidentiality risk. It creates a lot of security risk. The more they know about your network, the easier it is for a bad actor on their side to breach your network. So your risk goes up, your security declines, the more compliant you are with this particular provision. So you want to balance that out. Access to logs and on-site systems I would strike that. Most companies, if you have the leverage to do so, you're not going to allow that kind of information to leave the company. What you might offer in some cases is proof that it's occurring. So instead of them receiving the actual logs, you would be able to show them maybe a title header or the evidence of whatever IDS you're using, something along those lines. And usually you do that with a live screen share.
And
they'll be able to see that you're doing this.
You said IDS?
Intrusion detection system. So whatever you have that accesses attempts to, or logs attempts to access your systems, your network, that sort of thing.
Gotcha.
Yes, a 30 days notice, the second sentence here, that's fairly standard. Some provisions don't have a notice timeline. I would add one. 30 to 45 days seems pretty typical on my side. Carlyn, I think similar for privacy, probably.
Yeah, I see that one a lot too. Although I have also tried to draft in, sooner if a regulatory authority requires it.
That's a good
Yeah,
idea.
that's a good add as well. So that's something you can tinker with. It really is more of a business decision, unless you do have that regulatory involvement. The third-party auditor, that speaks more, it speaks to two things. One, it speaks to the security risk that I mentioned earlier. If you have a third party who's neutral, there's not that relationship at hand, they're less likely to go on a treasure hunt and try to find something to justify their presence. So customers may appoint a third party to come in, they'll be under NDA, you can add that here. What it also addresses, it also addresses, I think, a risk that they will stretch it out. Some of these can go on for months at a time. And so if they're bringing a third party in and they're paying them to do the audit, that ensures that it's not a large resource demand. The NDA provision is fairly common. So the last sentence I think is worth speaking to. What we essentially do here is this language is essentially outsourcing security decisions to the customer. If your client is a company that has its own in-house security, you want to understand how those decisions are made on a large scale. Your CISO may report to the CEO, he or she may report to the board. One customer is not going to be able to change their security practices or priorities. So what I would do is change this. I would add either a mutually agreed provision to any remediation plans that we are required to implement, or you can also add a provision that gives you the right to sit down and review and discuss. I've seen that accepted as well. And then you don't have that commitment to implement or remediate. I know we have similar provisions for audit around a lot of data processing. Do you see anything, Carlyn, that jumps out?
No, I agree with your last edit, which was, I see a lot of qualifying with let's sit down and discuss it, or, we'll only remediate any material, security problem that was identified.
One question I have is how frequently is this put into practice? Because I know a lot of different industries I work with, people have these robust audit provisions, but nobody ever does. Do you find it happens in real life more with the data security and cybersecurity?
I would say yes. Yeah. I don't know. What do you see on the data processing side?
It really depends on your client, whether they have the bandwidth to be able to perform audits like this. I've personally never been involved in anything. So, maybe my security group has, but for the most part, I actually haven't seen it used very often, but we definitely want that, right.
Is there if you were doing just a streamline, let's say I worked with a company that didn't have much money or many resources, but we still wanted some kind of audit provision, what's the minimum, to be able to, that you'd want to see for protecting yourself with your vendors?
So I know on the security side, if you can't show that you conduct ongoing oversight, you can be held liable to a greater degree for any of your subcontractor agents.
Okay.
Failings, non-compliance with regulations, that sort of thing. I would agree with Carlyn. It really does depend on the company. Yeah. I know companies that have dedicated teams just to conduct these audits of their vendors. There are companies springing up that you can outsource this function to, and they're doing very well. So it's a big deal. It's an industry. I think a lot of people do it, but it's very risk-based. So if you're supplying plastic forks to the cafeteria, they may audit you once every 10 years. Make sure you do a background check on your employees, and that's it. And if you're AWS and you're handling the entire the entire IT segment for them. They've outsourced that. They're probably going to audit you every year.
Yeah. And it's one of those, I haven't dealt with it in the cybersecurity context, but one of the key lessons I've learned over my career is get your business teams to tell you before they let somebody in to audit your systems. Because I've had it happen where I find out after the fact that they let a vendor in and they're doing all these things, and often the provisions don't allow them to, so, or at least set some parameters around it. So I think that's another reminder for all the attorneys and legal departments out there is, be in touch with your teams, make sure they're telling you.
Yes.
Okay, you ready for the next slide?
Yes, let's go to the next one. I was thinking too, as you said that a lot of the contracts have flow down provisions. So you might want to be familiar with your templates that your client uses with their customers, because those terms usually have to be, and I'll talk about it more, but they have to be mirrored to some extent in your vendor contracts as well. So another possible risk to consider. So security incident, the entire reason cybersecurity exists as a space. This goes by a couple of different names. I see it in contracts called security event, security breach, privacy breach, data breach. Carlyn's nodding. I'm sure you've seen the exact same thing. It can be so many things. What you really want, what I would do before I even look at this provision is go to the definitions and look at how they define it. I see it sometimes labeled a security incident, but solely defined as a data incident. I see it sometimes labeled as an attempt. If you're in a large corporation, there are thousands of attempts every hour to breach your network, and you're not going to be notifying them every time that happens. So first I would go to the definition, take a look, see what they consider to be a security incident. For this language, we are assuming that one has occurred. In theory, the first line has a phrase that it's kind of a pet peeve of mine, reasonably suspected. I'm not psychic. I'm going to go in and confirm that it has happened and it involves you, and then we'll notify you. So I usually pull the suspected. I don't find in practice that it serves a purpose.
Good point.
The 12 hours is I chose a fairly ambitious timeline, typically 24 to 72 hours. I know 72 hours is, I believe, Carlyn, the deadline in a data incident, right, for a regulator.
Yeah, that usually comes from GDPR. 72 hours is kind of like the longest you want to go.
Okay.
So yeah, so I'll see 12. I see 24 a lot, maybe depending on which side you're on, you start with the longest or the shortest and move towards the middle. So this language I think is generous, and that it asks for a notification when you become aware of the incident. I do see language that wants to know a lot about the incident. The shorter your timeline, the less the notifying company will know. They may not know the causation, they may not know really the extent of the damage. All they're letting you know is you're involved. So you can mobilize your incident response team, and your client will have an incident response team. They should. So you can just let them know and they'll get everyone pulled in. Most of them have phone chains. They do tabletop exercises every year, every 6 months. So they should mobilize and let you know if that happens. So it's going to be very bare bones. What I would add, in light of it being bare bones, is language requiring them to provide me with frequent and recurring updates throughout the investigation and the remediation period. You can put the content of those updates if you would like to. I always ask for remediation timelines. I want to know how long you're going to take, and I want to know when the remediation is done. Notification, I get pushback on the read receipt a lot for some reason. I think because a lot of companies now are automating some of the customer notification, and the software that they use is maybe less modifiable. So I would just ask if you're getting pushback there and try to understand what the concern is. That really helps. So the reimbursement of costs, that can be problematic. I always push back on that if I'm on the vendor side, just because it's one, I think you need to understand it ties to some extent into the liability provision that Carlyn's going to cover here in a bit. I also think it depends to some extent on the size of the companies involved. So I like to look at the Target breach back in 2013. It was an HVAC company, mom and pop HVAC. They had weak security. Their network was breached. The hackers, the bad actors sitting on their network. And then when they go into the Target payment portal to request payment, I assume the hacker is able to pivot onto that network. So in theory, the fault perhaps lies with the HVAC vendor. In reality, Target did not have adequate security protocols in place around its payment portal. They could have had multi-factor authentication. They could have had better segmentation. There were things they could have done, and they're a more sophisticated player, so it would be expected that they would be doing these things. So in reality, if you're looking at the cause, you can distribute that between the two parties. Or potentially, depending on the contract terms, allocate it solely to Target. So I would pull this out, or I would tie it to proximate cause. I would also limit it to direct costs. If you have the leverage to pull it all together, I would do that, and I would refer them to the liability or indemnification provisions. Again, the last sentence, necessary and appropriate corrective actions. We are again outsourcing the management of our security decisions to our customer, which for most companies is not feasible given their structure. So I would switch that to a mutually agreed corrective actions.
Got it.
And I'm interested, Carlyn, I know you have a lot of privacy incidents, and there's kind of a mirror version of this on the data processing side. Is there anything, I'm interested to hear your thoughts around privacy incidents and how you would approach.
Yeah, I mean, pretty similar to everything you outlined, but in terms of, the costs of covering for this breach, I think on the privacy side, it's better addressed in the liability provisions, which we'll go over towards the end.
Yes, okay, perfect.
Got it. Oops. There we go.
So this is the flow down provision. It has two parts. The first part is you have to flow down the relevant security terms to your subcontractors. Fairly straightforward. The language I would tweak here, instead of saying the terms, I would say substantively similar terms, or I would add a relevance provision perhaps. It's where I don't see this come up as a problem often in the future. Conducting an annual audit, I would tweak this to say supplier will maintain ongoing oversight at a frequency and to a degree commensurate with the risk. That gives me some flexibility to make my own decisions about where I want to allocate my audit resources every year. If I have a low risk vendor, I'm not going to audit them every year. And they don't want to be audited every year. It's a huge resource demand, and it's a security risk, right? You're sharing your internal information with an outside party. You can also, I think, ask for the request to see your results of your audits of your vendors. That usually violates your NDA with your vendors, and it subjects them to even more risk. So what I'll sometimes say is, we'll show you proof that we've audited. We'll show you proof of compliance. So we'll show you the title page. We'll show you the date. Really, the ultimate goal of these is to establish
I think we're having some audio problems with Raella, unfortunately.
Yeah.
I can speak to the privacy side of this.
Yeah, that'd be great.
While we wait for Raella to come back online. So flowing down data protection terms, cybersecurity terms, is a requirement generally of privacy laws. So you definitely want something like this. I definitely see, the same or similar qualification, which works.
Sorry, I think it's my turn this week, Laura.
Exactly.
Bad.
We were talking about the technical difficulties with all of us working from home and having, subject to the bandwidth world.
Hey, Raella, are you still?
Okay. Oops, I think you're.
No.
Well, maybe we'll just keep going and then we'll
Yeah.
please speak to the next one while we're.
Okay. So
Oh,
hopefully,
wait, I'm sorry. This was this one.
yeah, hopefully my internet holds up here.
Yeah.
So I'm going to speak to the privacy side of it. What is privacy? It is about protecting the rights of individuals to exert control over their own personal information. And it fits in with cybersecurity because, at least in my mind, and I'm not a cybersecurity expert, but the security terms are just part of protecting that personal data of individuals. To comply with privacy laws, it's really complex and it requires a lot of operational processes to be in effect. And contracts are really just one small piece of that. And so that's what we're talking about today. Your contract terms are really about limiting exposure of personal data by both, memorializing your organization's data protection preferences, as well as memorializing any legally required terms from the applicable privacy laws. There are a lot of different privacy laws in effect worldwide, and they are very much in flux right now. We have new ones popping up. We have updates popping up. European law is currently the strictest. I'm sure everyone has heard of GDPR, but I'm definitely seeing trends now in new laws that are, looking a lot more like GDPR. In the US, there's no comprehensive federal consumer protection laws, but California now has a law called CCPA, which is very similar to GDPR. All of this is to say that you're likely to need to update your contracts with new privacy required terms as laws continue to develop worldwide.
What do you recommend for that? I mean, because that's a challenge I think we all face, but this area of law touches so many different contract types. So keeping up with the change of law, do you do it through a change of law provision, or do you just deal with, comply with our policies and then change your policies? What do you recommend?
So most of the time when you look at privacy and security terms, they're probably in like an exhibit attached to a master contract, or could be standalone. And that's done because of, constant changes to these laws. And a lot of these documents I've seen, have a provision that say, we reserve the right to update this from time to time, change in law. So that's how you would cover for it. And I would also highly recommend working with local counsel in the countries that have up and coming privacy laws, not the least of which is, translation issues. A lot of laws might not be in English. So if you can get a local expert, that would be a great idea.
Got it.
So I see Raella's back on. I don't know if she wanted to go back or if we should just keep moving.
No, you're great.
Okay, good. Okay, so you can move on to the next slide, Laura. So I had a hard time, whittling down the sections for privacy. They're all really important, but I'm going to focus on really the fundamentals here. One of the first provisions you're likely to see is a purpose limitation. And I'll step back and kind of explain the roles of the parties, because that's helpful. And I'm going to borrow from GDPR because I think those terms are better. There's a data controller and there's a data processor. A data controller is the organization that determines the purpose of processing personal data, and the data processor has to follow the instructions of the data controller. Most supplier situations, not all, but most, the supplier is probably going to be the data processor. And so as I talk through these provisions, that's the assumption I'm making. So what should that section look like? It should limit the supplier's ability to process personal data except in accordance with the agreement, the applicable SOW, and your written instructions if you're the data controller. There really should not be any edits to this section. if you allow your supplier to process personal data for their own purposes, you have some compliance issues under CCPA. That might be deemed a sale. And then you have to tell your customers that you're selling their data, and then you have to provide a mechanism for them to tell you to stop selling your data, which is just really hard operationally. Plus, it just never looks good when you tell your customers you sell their data. So I would advise against that. And then in Europe, you know, there might be some question as to whether your data processor is also a data controller, and you just kind of don't want to get into that distinction. So hopefully no red lines, but you know, suppliers might try to push something through, who knows.
Keep going.
All right, so the next section, you can change slides. So data subject requests. They're in almost every law now worldwide. The data subjects, which is the individual, the personal data is about, they have enumerated rights over their data. I have written them down here in the slide. They vary from law to law. These are the most common. Really the two that you are likely to encounter are access and deletion. Access is, you know, the data subject comes to you and says, hey, give me everything you have on me. Deletion is delete everything you have on me. And responding to these requests is really time consuming and difficult because you know, you might have information about these individuals in multiple systems and with multiple vendors. So it's really important that you know where all your data is. But you also want to memorialize the supplier's obligation to cooperate with you and assist you in responding, because they actually might be in a unique position where they actually have all the data about the person and you don't. So what kind of red lines might you expect to see? I see the first one all the time, which is, you know, if the supplier's a SaaS provider, they say, hey, within the tool, you can, you know, delete yourself. You can download a file yourself. So we don't need to, you know, help you in any way. That's all right. I would say memorialize their obligation to always make that self-service tool available.
Yeah.
That would be a good one.
And is that common that, you know, delete me my records and it's just self-service and we just have to make sure that our systems actually do it?
Yeah, I see that a lot. Yeah. So which is helpful because, you know, it sometimes takes time for a supplier to respond to you when you're dealing with a data subject request. So if you can do it yourself, you can probably do it quicker.
Right.
But that segues into the next red line you're likely to see, which is timing and forwarding requests. Laws generally give you somewhere between 30 to 45 days to respond to these data subjects. Like I said, it's a lot of work. It's difficult to get everything together. So you want your supplier to cooperate with you as quickly as possible. And if they, for some reason, get a request from the data subject, you want them to forward that request to you as soon as possible so that you can respond in the legal time frame required. There are also in the laws a number of exceptions for you to have to like delete all the data that the data subject asks you to delete. They're enumerated. The big one I would say is, you know, especially related to the deletion request, that you don't have to delete the data if you have some legal requirement to retain it. Okay. And so a lot of times you'll put that in the contract. You know, you have a tax provider, they have tax laws require them to retain data for 7 years. So that's pretty cut and dry. I will say that don't trust your supplier's word on it. You should probably determine whether an exception exists or not. So definitely give your organization the ability to determine that.
Do you ever get deletion requests when you're still providing service? I saw somebody had posted that question.
Oh yeah, definitely. Although, I mean, it seems a little weird to me that someone would say, hey, delete all my data, but I want to continue being a customer of yours.
Yeah.
There are probably a lot of exceptions that are going to apply in, fully deleting all their data on like the transactional level. But yeah, it could happen.
So if somebody asks, do you just terminate their service and say, great, we will, but we can't continue to serve you? Or would that be a breach of the contract? Or I'm just curious how it plays out in a practical.
It would depend on the situation. And I think that there could be situations where you can say, okay, yeah, we can delete everything, but then like we can't do anything else in your account for you.
Right.
So it could happen. And then another edit that I see from time to time, and this is not unique to data subject requests. I think we brushed on it in the audit provisions, but paying for assistance. So like suppliers might say, hey, okay, well, we'll cooperate with you, but you have to pay us to do it. And when I see that with the data subject request, I don't like it because data subject requests are legally required. You have to respond to them, right? And so what the supplier is saying is, pay me to comply with law. So I don't like to see those. You can qualify them with, okay, well, we'll pay you for extraordinary effort beyond anything you do for other clients. Maybe your business is okay with a cost like that. So you can move on to the next slide. Okay. So it is highly likely in your career you are going to see a contract where there is international personal data involved. And even if there isn't, there's probably going to be some conditional language that if there is, then this cross-border transfer provision applies. I'm just going to focus on the transfer from Europe to the US, because that's probably what you're going to see if you are a US attorney. In Europe, transfer of European personal data outside of Europe is only allowed if the country's laws are deemed adequate or you're following some lawful transfer mechanism. And so, surprise, surprise, US law is not adequate. That leaves you with the transfer mechanisms. And until very recently, like a few weeks ago, there was a Europe to US specific self-certification program called Privacy Shield, which was invalidated. And that leaves you with standard contractual clauses, which is not just for US, it's for Europe to any country whose laws are not adequate. And I will say that even the standard contractual clauses were called into question by that court case, mostly having to do with US laws not being protective of enough of European data subjects because the US allows a lot of surveillance. That's the gist. I'm probably butchering it, but that's the gist. So I've seen a workaround lately about adding, language around law enforcement policy. So your supplier should have one, you should have one. But as of today, standard contractual clauses are still valid. The good news from a negotiation standpoint is that they can't be negotiated. Very few things in contract negotiation are that cut and dry, but you cannot change the provisions. So you can add appendices on top of it, but the bottom line is you can't change them.
That does make it a lot easier.
It does. And then one thing I do see though a lot is suppliers might bristle when they see any sort of international language because they don't actually process any European data. And so I'm okay with, removing international language, but I'll usually draft a statement saying that they're not processing international data, and that if they do later, then we're gonna have to come back to the table and do whatever we need to legally transfer the data. Because we all know the scope of services change all the time, and legal departments are not always notified when that happens. So it's a good stopgap measure.
Right. Okay.
Yeah.
Just change
So,
it.
yeah, let's change it, because this one's probably why everyone's here today. This is the biggest one. It touches, well, any portion of the contract really, but privacy and security are a big portion of it. You will fight over liability in your contracts. Security breaches now are more and more frequent. Suppliers are more and more sophisticated, and they know what it's going to cost them if they experience a breach, and their customers come after them. So personally, I have noticed a big downward trend in what suppliers are willing to offer in terms of liability caps. I think Raella has more experience in, representing the suppliers, so she can probably speak to, what the supplier calculations, risk calculations are. But I see a big downward trend in what is being offered in terms of liability.
Do you see it as a separate liability cap, or is it, like this is the normal one and then this is for cybersecurity issues?
Yeah, I definitely see that more and more.
Okay.
Yeah, a super cap. So you might have a different cap for a higher cap for security issues, rather than just your run of the mill kind of you breach a contract kind of claims. So what kind of liability should you be looking for? And again, I'm really assuming I'm like the data controller and the supplier's the data processor. Because I've been lucky enough to kind of always negotiate from that standpoint. But you want to try to get an indemnity from your supplier. In the privacy space right now, I would say the fines from regulatory authorities are going to be your highest cost, rather than individual lawsuits. But I think that's more a function of, maybe the law doesn't have a private right of action yet, or the courts are trending towards, saying that the plaintiff has not proven actual harm. But that may change as courts see more cases like this, or the laws change. But you definitely want to get your attorney's fees covered if you can, because you still have to, respond to this, and of course any settlements. But yeah, I think right now the fines are the biggest risk. I see increasingly suppliers not offering indemnities. They just won't give you an indemnity. And so then you can kind of pivot to getting specific costs covered. So I have this on the slide, but my favorite catch-all would be, any reasonable costs in mitigating the security breach, which could be almost anything. So if you can get that through, you feel more comfortable. You definitely also want to get your costs of notifying data subjects or regulatory authorities. If notification laws are triggered, or even if they're not, you might decide as an organization that you want to notify. I don't know. And then, if you can get through credit monitoring or running a call center, if it's like a really big breach and you're likely to have a lot of customers calling in, that would be a great cost to get covered. I think suppliers are more likely to cover those sorts of costs if they're outright refusing to offer an indemnity. But regardless, you're looking at a cap. Gone are the days that you can get uncapped liability for this stuff. Is really hard to give you an exact number. It depends on so many factors. Definitely want it in the millions though, because just, if you had to notify a whole bunch of data subjects, that's going to cost you probably in the millions just to get those notifications out. So what are your risk factors you want to determine? the number you're willing to accept for a cap. From the supplier side, their risk calculation is really based on the value of the contract, I think. And if you're lucky, maybe some multiplier of that. So if you have a high value contract, then maybe it's okay, but not all contracts are high value. So from the privacy side, when you're talking to your business stakeholders, because ultimately I think this is a business decision on what to accept for caps, you want to look at the type of personal data involved. So is it emails or is it social security number? Because the more sensitive it is, the higher your risk. The volume of data, is it 3 people? Is it 3 million people? The location of your data subjects, is it non-California US or is it Europe? So those are all good risk determinations.
One question, if I could, on insurance, and this is, I always know when I'm thinking about indemnity and limited liability, there's always an insurance play here. Do you see that as a meaningful way to mitigate data in this space, or do you typically, it doesn't usually apply?
So are you talking about insurance requirements for suppliers or insurance requirements for your own organization?
Really both. Just kind of where I'm thinking, indemnity and limited liability are ways to mitigate risk, and so is insurance. What do you see companies, both supplier and customer, or excuse me, processor and controller, does it, because some industries, insurance is a central part of the discussion around limited liability and indemnity. Other industries, we don't even worry about it. So I'm curious what you see with privacy and data security.
Yeah, so a lot of the contracts I negotiate as the data controller, we have our suppliers. They have to maintain a certain level of like cyber insurance. And so let's say it's $5 million. And, I have made the argument many times where, they might be offering a pretty low cap and they're like, oh, we'll only give you $1 million. And I say, well, but you've agreed to 5 million in cyber insurance. Why should you be able to recover 5 million for a breach and we can only recover $1 million? And sometimes that moves them, sometimes it doesn't. But it's a good negotiation tool. If they're being really stubborn, it's a good point to be able to make. But on the flip side, if you're the controller and you have your own cyber insurance, and you have a supplier that's being really stubborn and offering a really low cap, and you're counseling your business stakeholder whether or not to accept it, then you might want to look at your own coverage and say, okay, well, if they're only giving us, $500,000, we have 20 million in coverage, and usually breaches are not going to come anywhere near 20 million of a breach of this nature that the supplier, their services industry would have.
Yeah. And just heads up, we're at about 11 minutes to the hour, so we'll keep going.
Yeah. So some other issues or other risk factors you can consider is, your organization will probably have its own risk tolerance. So I know my organization's like what dollar range I'm looking for that I don't have to escalate within my organization or my business stakeholders organization. How critical is your supplier to the business? Can they replace them easily if things went south? What their working relationship is with the supplier, those sorts of things. So Raella, I don't know how much you caught of that, but if you want to add any color on the security side on determining what is a reasonable cap or anything like that.
Sure, thanks. Yes, apologies. I don't know, my Wi-Fi is being special today. I agree with everything you've said. The one thing that I've found helpful is it doesn't always work, but to put a number together based on industry published stats. And apologies if you went through that while I was fiddling with my Wi-Fi. So there are 2 resources I know on the security side that publish numbers related to the usual cost. Krebs on Security has a little bit. Ponemon, Ponemon, I think is how it's spelled, Institute publishes some stats as well. And so, for example, I think in 2019, average notifications went out to about 7,000 people per incident. And they publish costs for each incident for small and medium-sized business, large enterprise, that sort of thing. And so I find it helpful to go in and pull those numbers and extrapolate them to this deal, depending on how many data records we have or what the impact to us would be if, to your point, Carlyn, if it happened, and take that into the negotiation. And sometimes it helps reset the scale of caps that we're discussing from a really small number to one that's a little bit more reasonable. So something else to try.
Yeah, that's great.
And I'll put those in the Q&A.
Gotcha. Was there any other slides, or that's, oh, these cover this?
I take questions or go over the resources.
Yeah, if you just want to talk to the resources quick, and then we can start on some of the questions.
Sure.
So resources, I put these in here. I know there's a question as well in the Q&A on this. These are some of the easy way, I mean, it's easier than developing a lot of experience in the security space to put some of these in. What they are is certifications that set out the nuts and bolts of what you will be doing if you have a secure program. So you can go into your contract and you can link to one of these options. The NIST cybersecurity framework is a little bit more laid back than some of the others. PCI DSS is specific to handling payment card information. There are similarly certifications for the health space. I know that's mentioned in some of the Q&As. The federal space has its own. CMMC is coming up. I know FedRAMP has been a big one. But you can look at the certifications and frameworks and reference those, because I think we're all aware that there aren't a lot of really detailed security regulations out there for us to reference and look to. Hopefully we'll catch up to that at some point. So this kind of is a substitute that you can contract in as an obligation for your vendors.
Okay.
And Carlyn, I'll toss to you if you have anything to add as well.
Yeah, you can move on to the privacy resource slide.
Oh. Got it. Oh, there it is.
Yeah. So, of course there are laws, and you can always read the text of those laws, but these resources are helpful in giving you a shorthand of those laws or trends in the privacy space. So one of the first ones would be the IAPP, the International Association of Privacy Professionals. They publish a lot of articles. They're pretty useful. You can get on their newsletter. Electronic Frontier Foundation also has a portion of their website devoted to privacy. DLA Piper has a good resource if you're just looking for like super high level international law requirements. You can just poke around and click on countries and just see, do they have a law? What's it called? And that kind of stuff.
Yeah.
And then government entities and enforcement arms are helpful to look at to see, where your risk exposure might be based on trends and enforcement actions. The FTC has quite a bit published. The California Attorney General has recently started enforcing CCPA violations, so you can go and see what they're doing. I have the ICO, the Information Commissioner's Office in the UK there. Even despite Brexit, this is going to give you a peek into what European enforcement is likely to be. And of course, you can always set alerts on Google or, Wired and Washington Post, New York Times. They have lots of privacy articles, so you can just set alerts and just see what's happening.
Good idea. So thank you so much, first of all, for both of you, but we're going to start going into some of the questions that people have been posting, but there were a few questions in advance that people asked, so I want to cover a couple of those. One of the first ones was, how do you divide risk in your organization and assign responsibilities relating to data breaches and other cybersecurity incidents? For either of you.
So for me on the privacy side, most of the risk is probably better assumed on the business signing the contract.
Mhm.
I will counsel them on those risks, and they can decide for themselves, whether it's worth it to assume those risks. But I think on the privacy side, it's probably better allocated to the business.
Raella, do you have the same thing?
Largely, it really depends on your company structure, and it depends on where the lapse came from in the supply chain. If your business is the one interacting with the data or the network, then yes, I agree with Carlyn. If it's somewhere else in your supply chain, it may be someone else who's responsible for managing that. It just depends on how your company is structured, I would say.
Yeah. So one of the questions came from Carrie Schmelzer, who I know. Hi, Carrie. Is what insurance do vendors maintain or should maintain to cover the forensic and other costs associated with the breach? Are you familiar with kind of that, how to put that in place and what coverages they need?
I do know, Carlyn may know more than I do about this. I do know that there are companies, I believe, that offer specifically cybersecurity insurance. What I usually see is an errors and omissions policy.
Mm-hmm.
And it may be, depending on the size of your company, supported by a number of insurers simultaneously.
Okay.
Yeah, I mean,
again, it just depends on your client.
Sure.
Yeah,
Yeah.
sorry, go ahead.
No, there's definitely cyber insurance out there. It might be part of the E&O. It might be a separate thing. I'm not sure what exactly is covered, but I would imagine like forensic investigations and things like that might be covered.
Right. Now, somebody else asked a question about third-party vendor agreements that show up with no cybersecurity privacy terms. And how do you approach that? Especially if you don't, I would imagine, if you could address kind of when you have bargaining power and when you don't, because if you have bargaining power, it's kind of easy. But if you don't, what do you think the lawyers watching should do?
Yeah. So this happens a lot where the vendor is just like, nope, this is our form, take it or leave it. And usually they might be in the position where they have all the bargaining power because they have a monopoly on the services, or maybe they're Google or Facebook. Although Google and Facebook, they have targets on their backs, so they actually do the privacy stuff right.
Okay.
But you can always try to get your business, like someone very high up in your business, to try to pressure the vendor to move on it. If they won't move and you're gonna have to just assume the risk and sign it, in terms of enforcement, I think that regulatory authorities will look at that and say, oh, well, you tried, and this vendor doesn't change their terms for anybody, and like maybe that's a factor they're going to go easy on you if there's an issue.
Okay. Yeah, no, so it's enough that you're asking and trying and being diligent, or at least you hope it will be.
Yeah, I don't know. It would have to depend on the situation. But I mean, if it is something that your business absolutely cannot live without, and you get appropriate levels of sign off, you could sign it. But I mean, I wouldn't like to do that because laws generally require you to have privacy and security terms. But crazier things have happened.
Yeah.
To go in and ask, either do it yourself, depending on your leverage, or ask them to do a gap analysis. And so you can speak to the differences between your template and their template, as opposed to just rejecting the entire template. And then I think too, it can be helpful to go in and speak to the fact that you presumably have customer contracts that require you to have security obligations and pass them on. You'll be in breach of customer contracts, so you just cannot do this. But because you've done that gap analysis, you're bringing them a skeleton set of terms, hopefully, as opposed to a 6-page or 20-page template. You're saying, hey, can we put these like 2 little bitty paragraphs in? Is that okay?
Yeah.
And you may have to put it into the SLA level instead of the master level agreement, but just, you know, accommodating how it's presented as opposed to giving it up. That usually works. Although, yeah, I agree. If you have a giant, if you have AWS or Google, it's, yeah.
Okay, great. Well, we've reached the top of the hour, so I think we're all done. But thank you so much, Carlyn and Raella, for being here and for all that wisdom. I definitely learned a lot. So